And on that note, it looks like we have another caller coming in. And hello, caller. You're on the air now with Pony Radio. What's your question?
I heard you're not allowed to use character evidence. I don't even understand what character evidence is, when I can use it, or how I can use it. I mean, I don't understand how a character trait is any different than a habit that I do all the time.
Well, it's funny you should ask about the use of character evidence and then say you don't know what it is. You're no different than most lawyers. Most lawyers know you can't use character evidence, but they don't know what it is. And in fact, that's probably true of most judges. They have a general idea, but they don't have a very specific idea because it turns out it's not a very specific category of things.
What do you know?
It started out in criminal cases. And it started out as an idea that said, we don't want to make it too easy to convict somebody of a crime that they're being charged with now just because they had been convicted of other crimes before. That we didn't want to, we wanted to make sure that the prosecution had an incentive to put specific, particular evidence about this crime in front of the jury. And the judges in the mid-1800s were afraid that if they let the prosecution simply put in the fact that this person was a thief because he'd been convicted of other episodes of thievery, that the prosecution would be able to get convictions too easy because the jury might not care much if he'd actually done this one, or they might jump to the conclusion he'd done this one on weak evidence because they knew about the other ones that he'd done. So that was the basis for the restriction on character evidence. But like everything in the law, it takes on a life of its own. And now the notion of character evidence is much broader than that, and it applies in many other circumstances than that, and it is now so complicated and so difficult to understand when one is dealing with character evidence and when one is not dealing with character evidence that many people think that it has become a rule that needs real reform. Interestingly, many practicing trial lawyers sort of like the character evidence rule that way.
I can imagine.
And you can? You know why?
I think I do. Yeah.
What is it?
Well, I think it sort of helps them with their cases, if they can use that sort of against the person they're trying to prosecute.
Well, you're on the right track. I believe that what they think is that since nobody knows very clearly when something is offered to be for character uses and when it's offered to be for something besides character uses, and you're allowed to do that, that they can control how the case goes by how good they are at arguing this. Since there's no right answer, if they can convince the judge, then they can win, and it's often a very important point in the case. So they sort of like it that way because it gives them the feeling that it's their skills that determine the outcome of the case.
I see.
Now, whether or not cases should turn that much on the skills of the lawyer is a different question, and people could argue about that a lot. And once again, they do.
We like to argue.